One of the first questions I'd like to ask people, who knows what a trademark is? Oh, you right here in front of me.
I know it's like a logo or a slogan or a motto that's, you know, you apply with the U.S. Patent and Trademarks Office, and after 10 years it's incontestable to mark for your business to protect you from somebody infringing on it.
Pretty good. Anybody give me like one sentence, like a few words? Trademark in 2 words, a 2-word definition, is a source identifier. So you think of Mercedes-Benz, Coca-Cola, Betty Crocker, Duncan Hines. It's a source identifier. You don't necessarily have to know, for example, like with Betty Crocker that I mentioned, that it's Duncan Hines that makes the Betty Crocker cake mix. But like if my wife sends me to the store, usually the Jewel, to pick up some cake mix or something, she'll say, pick me up, you know, a box of Betty Crocker cake mix or whatever. So that's what you want to do. You want to take your mark and eventually make it a brand. Look at Coca-Cola, for example. It started out with Coke, Diet Coke, Coke Zero, Cherry Coke Zero, Vanilla Coke, you know, Vanilla Cherry Coke, and just from that single mark Coke, basically you've developed it into Coke, a mark, and you can put any number of products around it. Gentleman right here in the third row.
I just have a quick, what's the difference between trademark and being registered? You see the little R circle?
All right, well, a circle R means that it is in fact registered, that it's gone through the Federal Trademark Office and been approved and gone through the registration process. If it hasn't, you cannot put the circle R there. Usually, what you'll see a lot of times, and what I advise clients to do, is put a TM in the upper right-hand corner. And what the TM means is that whatever proprietary rights I can claim in this mark or potential mark, I am claiming. So I advise that to let people know and let your competitors know that you're going to claim this as a mark and that they should stay away from it. You can't change it to a circle R until you get the registration. One other thing, when I use the term trademark, I am also referring to a service mark. A trademark is generally goods. It's the majority, like 80-20, 80% goods, maybe there's 20% service with it. Service, there's the other sort of 80-20 flip on it. It's 80% services, maybe there's some good or goods involved, 20%. Okay. Now, what else can trademarks cover? For example, they can cover things like your packaging, the coloring of your packaging. It can also cover layouts like a restaurant. That's usually referred to as trade dress, but really it's just a little more fancy term for a trademark. I see the gentleman way in the back there has a question. Sir?
Leon, can you have one company with a service mark and another company with the identical phraseology as a trademark? And how often are they different and how often are they the same?
Well, that's a real good question, and there's no definitive bright line. But to give you an example of what I think you mean, and correct me if I've misinterpreted in the example I give here, you have Apple computers and Apple vacations. People aren't going to usually, especially in this day, confuse vacation with a computer. Usually a computer needs work. But for example, things sometimes happen. Sort of dating myself, those of you who remember the record label the Beatles used to distribute under was called Apple Records. Well, originally there wasn't a problem when Apple just did computers, but when they came out and invented the iPod and iTunes and started distributing music, that's the same thing that Apple Records essentially did, was distribute music. They wound up suing each other. They did eventually settle in the UK in mediation, but here's an example where the technology world got caught up and was under the umbrella of the mark. Again, no issue with Apple computers and Apple vacations, but Apple computer and Apple records, basically, there is an issue. Is that kind of that answer? Is that a good analogy for your question?
Pretty much.
You want to follow up on it or refine it?
I don't want to dominate the conversation. You said 80-20 for products on trademark and 80-20 the other direction.
Yeah, it's not a bright line.
Services, and I understand it's a blurred line.
Right.
So can one entity own phraseology as a service mark and somebody different own it as a trademark? Sounds like the answer there is yes, right? So
Yes.
Apple service mark, Apple trademark, different companies, right? Or how often are those controlled by the same entity?
Well, it depends how close the fields are. It's not only that the trademark examiner, he or she will not allow it, but also the competitor. Depends how close. And there's no bright lines. Like McDonald's, for example, a number of years ago, tried to come out with clothes. And they've tried to corner the MIC or MC market, that anything bearing that prefix, basically they control. Well, that's not true, but they warded off enough other competitors that they had clothes like that. So, would people confuse clothing with hamburgers? Doubtful. But on the other hand, they didn't want it to have the imprimatur of the MC, the McDonald's brand on it, to make it look like they were sponsoring it or otherwise supporting it. So there's no bright line that I can draw you for that. But the closer you get in fields and distribution channels, which means the channels that you sell in, your products and everything, the more you've got to take a look and examine and see how close you're coming to your competitors if you're trying to protect your business, or how close your competitors come to you if you're protecting your market niche and your market space. Dan?
So are taglines markable?
Yes. Yes, you can add a tagline to a mark. Like Nike, you'll see the swish, and then you'll see something like "Just Do It," or Toyota, "I love what you do for me," or lots of other taglines. You can also add logos to help distinguish it and draw it away from somebody else's mark. Follow?
As a follow-up, so as entrepreneurs, as we're inventing these things and rolling them out, what's our, of course we should see you for specific professional advice, but the general course is we just put the TM on it and then as a start?
No, you should do a little bit more than that, and this you can do without my help or any other trademark or intellectual property attorney. The first thing is go to the United States Patent and Trademark Office website, and that website is www.uspto.gov, and it's free. And there's a database of all the marks that have been registered and a lot that have lapsed or gone abandoned. You search that. So if we were to put in, for example, Apple, and we'd come up with tons of like Apple Computer, Apple Vacations and all that, we'd see what else is there. If we were going to sell milk and we were going to try to call it Apple's Milk or the, something like that, we'd probably find that it's okay. That's the first thing you should do. But that doesn't solve it, because there's state trademark registrations, there's common law marks which have never been registered, and you want to look into that. One way to do that also on your own is, I don't care whether you Google it, Yahoo it, Ask it, Bing it, whatever, you should run one of those search engines on it, and you'll see businesses as well as goods and services that come up with that. You can scan that and see these will be marks or businesses or services that aren't necessarily registered with the U.S. Trademark Office, but you want to avoid. In fact, before the next step would be, then you would come to me and I would order a full search report, assuming that it's clear. That preliminary search that you just did on the USPTO database, and let's say we Googled it, can only give you a no. It cannot give you a definitive yes. So if you hit something upon it, it's telling you no, you knocked it out. But if you don't hit anything in it, we haven't looked, for example, at the state trademark registration. We haven't gone through domain names where people are using them as a trademark, okay, and haven't registered them, but anyway are out there and using the domain name as a trademark and have the rights in that. So you want to do that preliminary search, and that'll knock it out. And I always tell, especially my business clients and everything, to start with a minimum of 2 and at least, and preferably 3 potential marks, because it takes anywhere. Now, the trademark office, as of yesterday, was claiming it was roughly a year from beginning to end when you file it that it gets registered. That does happen. I've seen it done as quick as 6 months, and it's taken as long as 18 months. I would say the average is about a year to 14 months. So in that time, when you're applying for it, whether it's an intent to use application or a use-based application, and I'll elaborate on that in a minute, is you want to have at least 1, if not 2 alternatives, so that when you're coinciding it to launch with your product or your service, that if something comes up and knocks it out, you have 1 to fall back on, that it isn't going to put your marketing stuff in a glitch. Now, I just mentioned 2 types of applications. There's a use-based application and intent-to-use application, and they are just like the name sounds. A use-based application is one where are you already using the mark, such as if we were Apple Records and we were going to put a new album out, a remix or something like that, that's already out there. If we wanted to expand it into a different field, like let's say the manufacturer of guitars or something similar to that, we already have a registration on that. We might apply to expand that registration, but we might already be using it. We might already have manufactured guitars or put, if it's an album, like a new remix out there. Intent to use is also what it sounds like. We haven't used it yet, but we intend to use it. This is a way to get a jump. You can file it, okay, and have it start going through the trademark process till you get to the point where it gets approved. You get what's called a notice of allowance from the trademark office, and then you've got to file a specimen of how you're using it, and it's got to match what you said in the beginning. You can't modify it, and you've got to file a statement as the owner that in fact you have used it in commerce, and that you're making a declaration, a statement that in fact you've used it. So that's what an intent to use application is, and those are the 2 types of applications that you can use to get trademark rights. Rich.
Hi, Leah.
Yeah.
If you have a federal registration already, is there really much benefit doing a state registration?
No, no. Federal is going to give you everything a state does. What a state registration typically does, it's just a codification of what the state code was regarding trademarks and everything. Federal is much broader. It gives you better, stronger rights in the fact that you can bring the lawsuit in any district court in the United States, anywhere, no matter where you want. You can essentially forum shop somewhat. State is basically going to be limited by the state rights and what the state statute confers on you. Under the federal registration, it's going to give you the benefit of basically all the rights under the Lanham Act, and that's spelled L-A-N-H-A-M-N. I'm sorry, H-A-M. That is the statute that governs trademarks, and you will get all those rights under a federal registration that you would not get under a state registration. Let's move on a little bit, and let's talk about a minute for patents. Okay, most people, when they think of patents, they think of inventions or whatever, but there are actually 3 types of patents. There are a utility patent, design patent, and a plant patent. Just to stop for a minute, most of what I'm telling you is in here in the handout, but not all of it. Like, for example, the USPTO website and certain other things. But most of it's in here. If not, and you have a question, you can certainly email me or give me a holler later, and I'm happy to answer the question. Well, anyway, a plant patent is just like what it sounds. And I've dealt with, out of the 24 years I've been practicing up here, I've dealt with 3 of them. So it's asexually reproduced seeds. So we're not going to spend much, if any, time talking about it unless somebody has a special interest.
Sounds like a great story.
Design patent is similar to what you think of a copyright. in that it is something that's purely ornamental. It's like looking at one of the pictures over there and saying, gee, that's got a nice artistic bent. It's something that's purely ornamental. That's what a design patent is. A utility patent is the way something works or it functions. And the way I use an example to keep it straight is if I was building a lamp, okay, and if I had artistic ability and I could put a little sculpture in the base of the lamp and you would say, hey, that's nice to look at, Leon, that's great. That would be a design patent. But the way the lamp works, turning it on and off, dimming it and everything, would be a utility patent. What's important, and where people tend to get confused generally, is in terms of, they say, well, I want to protect my idea, I want to patent my idea. It's not the idea that you can patent. It's not the idea that you can protect. It's the application of the idea that you can protect. So if you, for example, think of a better fuel injector for a carburetor, you could protect that. Just like Einstein could not protect E equals mc squared, but the way you make an atomic bomb is what he could protect. And copyright, which I'll jump here for a minute, which deals with the expression of the idea, is the same thing. And both patents and copyrights originate out of the Constitution. A copyright's an expression of the idea. So I can't protect or own the idea, boy meets girl, they fall in love. But if I could write real well, and I could write love story or Romeo and Juliet or something like that, it's that specific expression of that idea that I could protect. Okay. One other thing about patents is you don't need a prototype. A lot of times people say, well, I have to have a prototype. Do I have to do? No, you don't. 3 requirements for a patent are your invention has to be new, useful. What does useful mean? Basically, it has to work, and non-obvious. What do they mean by non-obvious? Non-obvious is not that it's non-obvious to me, or not that it's non-obvious to you. It's non-obvious to an engineer in that specific field of endeavor. So if we were building escalators, for example, okay, it's not that this modification or change or improvement would make it patentable because we don't see it. It's, would this been obvious to an engineer who works and designs with escalators? The sort of final category of intellectual property where you can seek protection is trade secrets. And what is a trade secret? Well, there's lots of definitions both in the states and the federal. Most states, it's over 44 now, have adopted the Uniform Trade Secrets Act. So that's what's in the paper here in terms of the definition. Well, what you can think of as a trade secret is that it's information that gives you an economic advantage. That's what makes it proprietary and makes it worthwhile. If that gives you an economic advantage over your competitor, and it doesn't always have to be positive, it could be knowing what not to do as well as what to do. But if that gives you an advantage over your competitor or the competitors in your industry, okay, that's a trade secret. Now, one difference between a patent and a trade secret, let's say there's 10 companies in this industry, it doesn't mean you're the only one that has to have the trade secret. 2 of you, or even 3 of you, depending on what the percentage is for that industry, could have that trade secret and not know it. It doesn't make it not a trade secret. Whereas with a patent, okay, a patent doesn't give you the right to do anything. It gives you the right to exclude somebody else from using, making, selling a product or use a process or a method. Is there a time here? I don't want to take
1 minute.
1 minute. Okay. Well, I've got to run to court, but I am coming back. I am happy to answer any questions. One of the statutes that I did fully put in here was about domain names. One thing you should know about a domain name is not a trademark. A trademark is not a domain name. A domain name can function as a trademark, but you have to use it as a trademark. And the Trademark Office has specific rules. I'll just defer the question in the back.
What trademarks or service marks should SBAC be thinking about pursuing?
I'm sorry,
What trademarks or service marks, if any, should the SBAC be thinking about for themselves?
Well, for example, usually initials are not great, but the fact that you've got SBAC and you've got that logo there, that specific design, that may be trademarkable and protectable. And I think if you're a business owner, just to sort of finish up, and you don't at least take the step of getting a state trademark registration, which is what Rich alluded to earlier, as opposed to a federal, because they're very cheap. The registration fee for a state trademark registration is like $10. It takes about a half hour to an hour of time. And if you're a business owner and you don't start protecting your mark because you want to develop it into a brand, I think that's a foolish mistake on the part of it. So the one thing I would do, and when I see Elliot again, presumably maybe even tomorrow morning at another breakfast, I will tell him that on your suggestion. Anybody else have any last questions before I turn it over? Sir.
So I could put, I have about 40 domains. I could put a trademark on each one of those?
No, you have to use the domain name as a trademark in order for it to qualify as a trademark. A domain name is like a telephone number, okay? It doesn't mean anything in and of itself. However, the telephone number like 1-800-HOLIDAY INN, the Holiday Inn is trademarked. It's trademarkable. So that phone number is trademark protected. Similarly, with domain names, you would need to do the same thing. You'd have to have it spell out something like Holiday Inn as your domain name, have that trademark, and then the domain name's being used as a trademark and therefore protectable as a trademark.
So, like for example, I own one of my sites is killerblogpost.com, and I actually have that as the theme, it's the header and everything.
I'm sorry, blogpost.com?
Killerblogposts.com.
Killerblogpost.com.
Yeah.
You could apply for that as a trademark, but you've got to use it as a trademark. Okay. Depending on what you use that blog for, it might be descriptive. Like if you're describing all sorts of serial killers, it doesn't sound like you're doing it, but let's say you were, the trademark office might object and say that's descriptive. That would be a descriptive mark. But let's say you're talking about, killer golf shots.
Well, that one's, it's like Wake the Dead with your killer blog posts. I got it with the early morning.
Okay. Well, but let's say it was something different, like killer golf shots. Okay. Because killer golf shots, there's nothing inherently descriptive about a golf shot being a killer or whatever. That's something that you could probably protect as a trademark, even though it starts out as a domain name. I want to thank you for your time. I'll come back happy to answer any other questions and everything. I hope this has been productive.